I think everyone would agree on would be that the framers of the original Constitution, like the drafters of the 14th Amendment, spent lots of time thinking a lot of deep thoughts about the exact language that should be used. And I think we should all assume that those words were chosen with care. And the words in Section 3, in multiple ways, mimic the exact language of the underlying Constitution. Officer of the United States. They use that phrase exactly. They use office under the United States. They don't use officer under the United States. No one ever uses that language. It's office under the United States, officer of the United States. The oath. So here's an important point I would make. Petitioners say, well, they're synonymous, doesn't matter. They really sort of include the same. But if you think about what actually happened with the framers, they have before them a United States Constitution. The original Constitution. the drafters of the 14th Amendment. And there are two oaths, one that clearly applies to the president and one that clearly applies to appointed officers.
Although, as Justice Marcus pointed out, there's no language under Article 6. It just says swear an oath.
An oath.
There is language. The language says to support. Now, people interpret it differently, but that's the language of the Constitution. And my point is this. The drafters of the 14th Amendment said, what oath am I going to choose? They chose the Article 6 oath. Remember, they had before them choices. They could choose the Article 6 oath. They could choose the Article 6 and the Article 2 oath. They could choose neither oaths, or they could choose both of them. They chose one and one only, the one that did not include,
the one that covered everybody. I think that's also, it seems to make no sense to me. I'm going to circle back to the absurdity argument that if the purpose of Section 3 was to punish oath breakers, that you would set up a provision that punishes those who break the lesser oath, but exempts persons who break the arguably more serious oath to preserve, protect, and defend. What is the rationale for that type of exclusion?
Is it a lesser oath versus a more stringent oath? I think that's a presumption we're making that may or may not be warranted because there's not much case law defining the two.
So can you make the argument that an oath to support is stronger than an oath to preserve, protect, and defend the Constitution?
Preserve, protect, and defend are specific words, specific actions. Support is a general category and far broader. Support can mean all kinds of things. As
like
shown,
preserve, protect, and defend.
Can mean that, but it can mean other things. Or it could be viewed as narrower. The preserve, protect, and defend are very strong charges, and support is to help those who preserve and protect.
And so the logical consequence of that, though, is that the president doesn't have a duty to support. I mean, that's your argument, right?
No, my argument is this. My argument is that the drafters chose specific language, and the language they chose was language that the underlying United States Constitution treated as separate things. We can argue about whether the underlying Constitution should have treated them as separate things. We can argue about whether functionally they should or should not be separate things,
I think
but the drafters of the 14th Amendment made a choice.
I think that what we're asking about is the meaning, and what you're arguing about is the meaning. And what I hear you saying is support is a lesser standard.
No, what I'm saying is this. I'm saying the meaning is that the drafters chose to exclude the United States, the presidency, by using specific language. I'm sorry, the president, the officer of the United States. My point is the drafters made a choice to exclude.
Why?
By choosing the support oath language, which mimics exactly Article 6, which applies to appointed officers, and they did not choose the Article 2, which applies to the president.
And I guess I read a lot of briefing over the last couple of weeks. I saw no rational reason for that type of an exclusion.
The historical record is devoid of that discussion. We can make it up here. We can come up with ideas.
We have a lot of historical evidence to the contrary, suggesting everybody thought that it did include Jefferson Davis.
I would suggest that there's a real paucity of evidence. When you actually analyze the citations made by the petitioners, it comes down to roughly one or maybe two newspaper articles during the entire ratification debates. I would not concede that point, Your Honor. I do not.
Can you come up with a rational basis for excluding either the office of the presidency or someone who swore an oath as a president
I think
from the Section 3 disqualification?
the answer is yes. And I think the drafters, they rejected McKee's draft. They removed the presidency, the president, and they added presidential electors in. And
I
that was the
understand the
mechanism.
textual argument. I'm trying to understand the basis, the rationale. Why?
I think that is the rational argument.
The rationale, not the rational. With an E, rationale.
I think that is the rationale, Your Honor. I just do. I think that's what we need to accept, is that the framers, the drafters of Section 14 made those choices in that era, and it's not absurd because it worked.
So the choice you're saying is that they chose to include the electors instead of the president?
Yes.
But to accomplish the same purpose, in other words, the electors, if this worked as designed, would prevent anyone from that, in that situation, from assuming the office. So why go about it indirectly when you could just go about it directly?
I guess we go into a more, I don't want to use the word metaphysical, but a more abstract argument is, if the entire nation chooses someone to be president, can that be an insurrection? Or is that democratic choice? Remember, the president is a little bit different. Everyone in the country has an opportunity, or should have an opportunity to vote for that person.
Oh, go ahead.
I don't think anyone here is suggesting, and I don't take the petitioners to have been arguing that the election of a person as president is an insurrection. I think that what the insurrection might have been is a different question. So I'm not sure where you're going with that argument.
I'm going with the broader context of the president is different, and if everyone in the country chooses a particular person as a president.
So if everyone chose an insurrectionist, Jefferson Davis, let's use that example. If Jefferson Davis ran a while ago, and the electors who were not themselves insurrectionists chose to put him into the presidency, that would be fine under Section 3, and that would be consistent with the purposes of Section 3.
That would be the rule of democracy in work.
But the
Yes.
rule of democracy, there are limits. I mean, the president can't be under 35 or can't be, someone who wasn't born in this country. So you could, the argument, that if you take your argument to the limit, it would say we can elect Governor Schwarzenegger or, my 27-year-old kid.
I don't think it goes that far. It's that rule embodied in the text of Section 3. Now, there are plenty of anti-majoritarian measures in the structural Constitution, and there are these qualifications. No one argues that. But when we're interpreting Section 3 of the 14th Amendment, and we look at the history behind that and the context and the language they used to satisfy the conditions of Section 3, you have to be an office under the United States. You have to hold the office under the United States, and you have to be an officer under the United States, and you have to take an oath. You have to have all four of those items in place. Any one of them, Section 3 does not apply.
Stepping away from Article 3, though, for a second, and sticking with the Constitution, could the Democratic Party put President Obama up on the primary ballot? Could that happen?
I haven't done a full analysis of that particular provision, Your Honor. I'm really sort of focused more on Section 3, but could they do it? Conceivably, I think it's an open question. If you look at the political question analysis of the Article 2 courts, the weight of authority was that states could not prevent that.
If I understand your democratic process argument, that would seem to be the logical conclusion. I'm just trying to make sure I understand the breadth.
The breadth is confined to Section 3, Your Honor.
But stepping away, because you were focused also on the Constitution.
Look, I'm focused on the structural Constitution to look at the language. Officer of the United States is used 4 times in the structural Constitution, and each time it does not apply to the U.S. president.
Go ahead.
I mean, not once does it apply.
No, I know.
Officer of.
You didn't answer my question, but that's okay. I'm not going to, I want to let you use your time the way you want to use your time.
So I feel like we're
Please
going,
feel free to take another run at me, Your Honor. I do want to be responsive. Yes, sir.
I feel like we're going in circles to some extent right now. I'm just wondering if we could shift gears. I was hoping to talk about the First Amendment and Brandenburg. Obviously, you've briefed at length the assertion that President Trump did not advocate violence in his speech on the ellipse. And so the counterargument to that is that we have to look at context, and they assert that we should, well, the trial court obviously did place a lot of reliance on Professor Simi's testimony and coded language. I'm just wondering if you can give us your perspective on the extent to which precedent allows for that kind of analysis. I struggle with what I see as a lack of precedent on that particular issue, how far context goes. What's your take?
Context plays limited and probably almost no role. Now look, this isn't a case, the incitement, and obviously we contest that incitement is part of engage. Happy to address that as well. But this isn't an instance of sort of planning, joint planning or a joint agreement where President Trump had specific conversations of back and forth. That's not what this is about. It's about inciting based on his public speech, That's what it's about.
So in saying that, I apologize for interrupting, but are you saying just look at January 6th and nothing else?
I will look at both, but